Hello, madam. My name is Elisha Cassandra, and today our group, which is Group 4, will be presenting the topic of winding up a company. So, what is winding up? Winding up is a legal process where a company's existence is terminated. That is the definition of winding up. Winding up. So, what is the purpose of winding up? Winding up is to collect and also realize the company's assets, discharge its debts and also liability, and also distribute any remaining balance among the contributors. So now let's have a brief look on the how the process is going to be for winding up a company. So first, it involves three main steps, which is the first one is asset collection, which the company's assets are gathered and also being sold, and next is debt discharge. Uh, the company will proceed from the asset sales they use to pay off the company's debt and also distribute it to the contributors. And that is the third step, which is distribute to the contributors, which any remaining funds will be distributed among the shareholders and also the contributors. All right, so now we are going to proceed with the methods of winding up. Method of winding up has two, which is the voluntary winding up and also winding up by court. So, voluntary winding up is initiated by the company itself, typically when it is solvent and is governed by Section 439 to 451 of the Companies Act 2016. And there are two types of voluntary winding up, which first is the members voluntary winding up. This one is for the solvent companies, and then creditors voluntary winding up, which is for the insolvent companies. So next is the winding up by court. So this one is initiated by a petition to the court under section 465 of the Companies Act 2016. So various party can initiate the petition for winding up, which include the company, creditor, contributory, liquidator, the minister, Bank Negara Malaysia, and also the registrar. And there are several grounds of winding up by court, which is passing a special resolution, default in filing statutory reports, failure to commence business, having no members, inability to pay debts, directors acting in their own interest, expiration of duration, just and equitable grounds, license revocation, and also unlawful purpose. So that's all for my part. I'm going to pass it to the next person. Thank you.
Hi, my name is Rosmawati. So now we continue with the step of um, to declare voluntary winding up, right? So there is 10 step here, right? That should be follow, which is the first one is boarding resolutions. In this, the process must begin with a resolution by the company board or the director. So the second one is declaration of solvency. This is only for the member, right? Member of voluntary winding up. So in this case, the director must make a declaration that the company is solvent and can pay the debt within 12 months. So the third one is make a shareholder meetings. Okay, in this case, in these situations, right? Member voluntary up must require 75% majorities of the situation lah. So the fourth one is appointed of liquidator in this step. Alright, the shareholder must appointed liquidator to manage the winding up process, and then also to distribute the sales. Alright, so The next one is notice to authorities. So this is related to notify the SSM, right? SSM is Company Commission of Malaysia, alright. So in that process, that should be published in 10 days, right? So number 6 is creditor meeting. So in this situation, alright, this is only for the creditor lah, alright. So if the company is insolvent, a meeting of creditor is held to discuss the winding up and appointed a liquidator. So this is within 14 days, right? So the 7th step, right? So is statement of affair. Alright, in this step, the director present a statement of affair of the company, right, to declare the company asset and liabilities. So number 8 is a liquidation process. In this process, the liquidator take control of the company asset and also pay off creditor and distribute any remaining asset to the shareholder. So the second last is for the final meetings, alright. In this situation, the liquidator calls a final meetings of shareholder and the creditor also to present the final account and the report. And the last step is dissolution, right? After the final meeting, the liquidator files the account with SSM and the company is formally dissolved. Okay, now let's move on to the differences between members and also creditor voluntary winding up. So there is 4 differences here, alright, which is the first one is solvency, the second one is initiation, the third one is liquidator appointed, and the fourth one is creditor involvement. Okay, now let's move on to the solvency. Okay, for member voluntary winding up, the solvency is to initiate when the company is solvent, and the director must make a statutory declarations of solvency. For the creditor, to initiate when the company is insolvent and unable to pay a debt. Right, so let's move on to the initiation. For members, this to initiate by special resolutions of the shareholders, and by the creditor, it's begin with a resolution by shareholder but involves a creditors meeting to appoint the liquidator. So the third one is a liquidator appointment. Right, for member, liquidator is appointed by shareholder, but for creditor, they have a significant say in the appointment of the liquidator. Means they have right to make a choice. Alright. So the third one is creditors involvement. So for member voluntary winding up, there's a minimal involvement from the creditor. Alright. So for the creditor voluntary winding up, so in this situation, the creditor are heavily involved due to the insolvency of the company lah. So that's all. Let's move on to the next slide. Okay, now let's move on to the case law. There is 2 case law here, which is the first one is Ri Lo Siong Fong, 1985, right? In this case, okay, it's involved the necessity of a proper declaration for initiating a member voluntary winding up of a company. So the issue here is whether the statutory declaration is made by the director and it met the requirements. So the court held that a proper statutory declaration must be made by the director, and the director must confirm that the company is solvent and able to pay its debt in full within a specific period, which is 12 months, right? And failure to comply with these requirements, they could make the winding up process invalid. So the next cases is Ng Aba and others against Director General of Inland Revenue. This case is on 1983, right? So this case actually highlighted the implications of creditors, right, meeting the appointment and also the liquidator, right, in a creditor voluntary winding up. So the dispute arise, right, over the proper conduct and produce of the meeting and the legitimacy of the liquidator appointed. So the court held that the importance of following statutory procedure is in conducting creditor meeting and appointed liquidator. So it's very important, right? So the rule is if any deviations from the procedure, it could be if affect the validity of the winding up process and also the subsequent decisions that made by the liquidator. Okay, now let's move on to the statutory provisions. Alright, this is the Company Act 2016. So there is 6 here. Alright, the first one is Section 439. This is for to define the initiations of voluntary winding up. For Section 440, this outline the declarations of solvency by the director. So Section 441 is for the procedure for member voluntary winding up. So Section 443, it's cover the procedure for creditor voluntary winding up. For Section 456, to cover the duties and powers of liquidator. And Section 459 is to cover the filing requirement for final meetings and also dissolutions. So now let's move on to the insolvency, right? What is insolvency? Okay. Insolvency is referred to the inability of a company to pay its debt, right? So when a company recognize that they cannot meet the financial obligation, so it is the option for creditor voluntary winding up. So let's move on to the process. Alright, there is 3 process here. The main process, which is the first one, is the director of the company must acknowledge the insolvency. The second one is a special resolution must be passed by the shareholder. And the third one is a creditor meeting. A creditor meeting is then convened to discuss the winding up and appointed a liquidator. So let's move on to the statutory. There is 3 here, which is the first one is Section 440 of the Company Act 2016. Alright, it's cover the procedure of declaring insolvency and initiating a creditor voluntary winding up. So on Section 443, it's cover the details of the process of a creditor voluntary winding up, to including the role of the creditor and also the appointment of a liquidator. So the third one is Insolvency Act 1967. So now let's move on to the case law. Wait, there is 2 case law here, which is the first one is Re-TPP Industries Syndrome Berhad 1997. This case illustrated the process and the necessary action when a company is deemed insolvent and also appointed for a creditor voluntary winding up. So the second one is Southern Textile Ltd Limited, okay, 1957. So in this case, the court consider the procedure and the evidence requires to prove insolvency for the purpose of winding up. Alright, now let's move on to the special resolution by shareholder. Alright, a company can be wound up voluntarily if the shareholder pass a special resolution to that effect. So this type of winding up is typically referred to as a member voluntary winding up when the company is solvent. Alright, so let's move on to the process. Alright, there is 3 process here. Alright, so the first step is a special resolution requires a 75% majority of the shareholder votes. Right, so the second one is the director must make a statutory declarations of solvency and stating that the company can pay its debt within 12 months from the commencement of winding up. And the third one is the resolution is followed by the appointment of a liquidator by the shareholder. So let's move on to the statutory provision. There is two here, which is section 439 of the Company Act 2016. It's covered the define the ground of the voluntary winding up, and also include the requirement for special resolution by the shareholder. So under section 441 of Company Act 2016, it's specify the procedure for member voluntary winding up, and also including the declarations of solvency and the roles of the liquidator. So the last part is the case law. There is two case law here, right? Which is Ri Long Xiong Fong, 1985. So in this case, it's highlighted the necessity and also the implications of the statutory declarations of solvency in the context of members' voluntary winding up. So the second case is Hap Seng Reality Syndrome Berhad against Tam Tong Reality Syndrome Berhad, 1989. So in this case, it discussed the requirements and also the legalities of special resolutions in the voluntary winding up. And that's all for me. Thank you.
Hi, my name is Adam Daniel. So, I would like to present my part, which is the voluntary winding up by court. So, uh, let us start with the who may petition for the winding up. Okay, so the eligible petitioners under the section 461, this section of the Companies Act 2016 outlines who is eligible to file a petition for winding up a company. So the eligible petitioners also include the company itself, the creditors, including the contingent or prospective creditors and contributories, the liquidator, and also the registrar of the companies. So let us look at some of the case law that we can refer to who may petition for the winning up. Okay, so the first one is the case of Miharja Development Sdn Bhd again Tan Sri Dato Loy Hian Hong, and others. So, the summary of this case involved shareholders petitioning for the winning up of the company on grounds of operations. So, the significance of the case is the court considered the rights of shareholders as contributories in the winding up process. So, the right of the shareholder is the key point on this case law. The next one, we can see the Tanyaju against Sinyi Estate Sdn Bhd case. The summary of the case is a creditor petition for winning up due to the company's inability to pay its debts. So the significance of the case is it is highlighted the position of creditors in initiating uh, winning up proceedings. So the position of creditors is the main point on this who may petition for winning up. Okay, let's go on to the next slide. Voluntary winning up by court. So number two, we have the grounds for winning up by court, part one. So uh, the grounds under section 465 clause 1 A to J. So basically, the section 4651 it lists the specific grounds on which a company can be wound up by the court, including the inability to pay debts, directors acting in their own interest, and also the company being just and equitable to wind up. So let us see some of the case law examples that we can relate under this section. So the first one is the Rejuvenate Coffee and Co. case. So basically, the ground of the case is the failure to commence business within a year or suspension of business for a whole year. So the details of this case is the company was unable to commence its primary business, leading to a petition for winning up. So the outcome of this case is the court ordered winding up due to the inactivity of the company. So another one that we can refer to is the Thomas Edward Brinsmead and Sons Limited cases. So basically, the ground of the case is that the directors acting in their own interest rather than the interest of the company. So the details of the case is basically the directors engage in fraudulent activities determined to the company. So the outcome of the case was it is winning up ordered to protect all the shareholders and the creditors. So let's go for the next part, which is the voluntary winning up by court. So uh, the next part is we can see in the case law examples the Ray ENH Tobacco Limited. So the ground of the case is just an equitable to win up. So the details of the case it is irretrievable breakdown in the relationship between the directors, the company directors. So the outcome of the case is the court found out that the deadlock made it just an equitable to win up the company. So the key point there is that the deadlock made, which is the breakdown in the relationship between the directors. So the next case we can see the Lock and Another against John Blackwood Limited. So the ground of the case is directors acting in their own interests, failure to hold general meetings, and failure to provide information to shareholders. So the details of the case is the minority shareholders sought winding up due to oppressive conduct by the majority. So the outcome of the case is basically the court ordered winding up to protect minority shareholders' rights. So that's all for my part. Thank you.
Hello, madam. So my name is Muhammad Fahim. So I will be the last presenter for this group. So I will be starting off with just and equitable grounds. So the just and equitable clause allows a court to wind up a company when it's fair and reasonable to do so. This might be due to a severe disagreements among the members, loss of trust in the company's management, or other reasons making the company's continued operation impractical. Next, we have additional specific grounds. So the first one we have corporate substratum failure. So when a company's fundamental purpose or main business objective fails or becomes impossible to achieve, the court may order winding up. So Section 465 of the Companies Act 2016 outlines the grounds for winding up. So next we have breakdown in member relationships. So when there is a complete breakdown of trust and communication among the company's members, making it impossible to run the company effectively, the court might step to wind it up. So next is loss of confidence in management. So if the shareholders lose trust in the company's management due to misconduct, negligence, or pure management, and it's clear that the company can't be managed effectively, the court may decide to wind it up. So next is business carried on fraudulently. So if the company's business activities involve fraud or are conducted with an intent to deceive creditors or shareholders, the court can order its winding up. So next is the facts and judgment of the case. So the first case we have is Regiment Date Coffee Co. 1882. So the fact of the case is the German Date Coffee Company was formed to manufacture coffee from dates using a specific technology. However, the technology was unsuccessful and the company was unable to produce coffee as intended. So the judgment of the case is the court decided to wind up the company on the grounds that its main purpose had failed. Since the company could no longer achieve its primary objective, it was just unequitable to wind it up. Next case is Ray Thomas Edward, Brinsmet and Sons, 1887. So the facts of the case is the directors of Thomas Edward, Brinsmet and Sons were found to be engaging in fraudulent activities, including issuing false statement about the company's financial health to attract investment. For the judgment of the case, the court ordered the winding up of the company due to the fraudulent actions of the directors. It was determined that the continuing the company's operations under such circumstances was unjust and inequitable. So the next case is Rare Yannick Tobacco Co. 1916. So the facts of the case is the Yannick Tobacco Company had two directors who were also the sole shareholders. They were in a complete deadlock, unable to agree on business decisions, which resulted in operational paralysis. So the judgment of the case is the court decided to wind up the company on just and equitable grounds. The deadlock between the directors rendered the company non-functional, justifying its winding up. So for the last case is Locke against John Blackwood, 1924. So the facts of the case is the shareholders lost confidence in the management due to a lack of transparency and suspected misconduct by the directors. The directors were not providing necessary information about the company's affairs, leading to mistrust among the shareholders. So the judgment of the case is the court ordered the winding up of the company because the directors' actions led to a significant loss of trust and confidence among the shareholders. It was determined that the company's management was not acting in the best interest of the shareholders, making it just equitable to wind up the company. So that's all from us. Thank you.
So we come to the end of our presentation. So in conclusion, winding up is an essential mechanism in corporate law that provides a structure approach to dissolve a company. Whether it is voluntary or compulsory, the process ensures that all legal and financial obligations are met and that stakeholders' interests are safeguarded. So this orderly and fair process is very important for maintaining trust and also integrity in the business environment. So that's all from us. Thank you.